Part 3. Divorce by mutual consent. Divorce by mutual consent is governed by Section 52 of the LRA, where it provides that petition for divorce by mutual consent may be made after 2 years of marriage, with the conditions that, firstly, there must be a free consent from both parties. Secondly, there must be a proper provision for the wife. Third, there must be proper safeguards for the support, care and custody of the children. And number 4 will be any other conditions as they think fit. The rationale for this is that mutual agreement between couples, it should protect the best interests of the parties involved. It requires that the proper provisions be made for the wife and the support, care and custody of the children of the marriage. These proper provisions must be freely agreed upon by the court as fair and reasonable before the decree of the divorce can be granted. In the case of Sivanasan, a joint petition for dissolution of marriage supported by affidavit which provided the settlement of the matrimonial property and a waiver by the wife of all future claims for maintenance. The court granted the decree nisi and then adjourned the matter to deal with the property settlement. Before the decree became absolute, the husband died. The Supreme Court held that there must be proper provisions and exact terms or conditions for the mutual divorce. The court went on to hold that there would in effect be no divorce and the wife, being a widow, was entitled to claim for the properties. In the case of Rigo Ho Ling, this was a joint petition for divorce, and the court held that both petitioners must be physically present in the court so as to satisfy the court that they freely consent to the dissolution of their marriage. The material times to consider as to the terms and conditions of the deed would be on the date of hearing of the petition. It is an important condition for divorce by mutual consent to prove breakdown of marriage as stated in Section 57 of the LRA. In the case of re-divorce petition, the principle stated is that mutual consent by the spouse to a decree of dissolution does not entitle them to a divorce. The parties who petition for a divorce on the ground of mutual consent must prove the breakdown of marriage. Moreover, Section 57, subsection 1D provides that a statement of principal allegations is to be proven as evidence of the breakdown of marriage. This is the end of Part 3.